Good evening, everybody. Thank you very much for coming along to listen to this financial remedies update. I can't see you all, but if anybody has any difficulties, please get in touch with the clerks by email, telephone, carrier pigeon, however is the best way of dealing with it. I'm afraid that Hannah is not with me this evening. She's suffering from some illness and has more or less lost her voice. So I'm afraid you've got to put up with just me. Very sorry for that. But without further ado, let me launch ahead. So the first topic this evening, maintenance pending suit. The case of Rattan and Quwad. Here, this was a second appeal in a maintenance pending suit case, believe it or not. The deputy district judge had ordered £2,850 a month, but the circuit judge set aside the order. He criticised the lack of a specific MPS budget and felt that he couldn't substitute an order of his own. The Court of Appeal considered it and looked at the principles, well-known principles in TL and ML, with which you should be familiar, I hope, but that you have a specific MPS budget, that short-term needs, etc. And in this case, the Court of Appeal applied TL and ML, but gave a little bit of relaxation in this obviously modest money case. They said not all budgets require a critical analysis. Here the wife had simply used her Form E budget, and the deputy district judge had undertaken a fairly broad assessment. He did not need to go through it line by line, they said. Merely because an item of expenditure may not be monthly does not mean it should be excluded. The wording is that the order should be reasonable, and the circuit judge had been wrong to exclude some items or to criticise some items as being not immediate expenditure needs. They confirmed that school fees can properly be part of a maintenance pending suit budget, notwithstanding the fact that they are paid, well, either annually or termly. And finally, they unsurprisingly said that if a circuit judge overturns an order of a district judge, they should impose an order by way of substitution. So, as I say, just a little bit of relaxation of the strict rules in TL and MR, which is quite a large money case. Legal fees funding, LAPSO applications. This decision, LP and AE, first of all, the amount spent by the respondent is potentially a relevant consideration. The first instance judge had said it's not, and they said, well, plainly, it may be. In this particular case, it transpired during the appeal, or in the run-up to the appeal, that the husband had spent 560,000. The wife was actually seeking 99,000. It's fairly plain to see that that figure of the husband's made a substantial impact upon the court. The case also reinforces the distinction between historic costs, which were the bête noire in Rubin, the case of Rubin, where they said that historic costs could not be awarded on a lapso application, and unpaid costs. They confirmed that there's no bar to recovery of reasonable and legitimately incurred costs incurred within the ongoing proceedings, but prior to the determination of this application. But the delay in making the application meant that not all those unpaid costs were recouped. So the wife delayed issuing between the 20th of September, when the husband had clearly refused her request for funding, to mid-November, and the application was eventually heard in mid-December. So she lost some of the costs which she would otherwise have been awarded. So the takeaway from that is, do not delay. I think we all know that making applications for interim maintenance, maintenance pending suit, and cost funding, really you have to be turning your mind to those issues right at the very start. Otherwise, the delay will make the effect of the orders irrelevant, or you'll get swept up in other things. The next case is AJC and PJP. Now, this is a decision by a deputy district judge, and one has to say that is not the most weighty authority you might think. But the facts are quite interesting in the sense that here was an application to vary a nominal order into a substantive order. And the judge said that this is intrinsically different to any other type of variation application. He said that they should only be granted if there was a significant change in circumstances, not just a 20% increase or decrease in the income of either party. Secondly, this had not been budgeted for by either party in the planning of their life. And this is relevant in circumstances where parties were encouraged to move on. Well, the legislation encourages parties to move on, although you might say the presence of a nominal maintenance order means that the court has not felt able to determine the obligations. He said the mere fact that it was not clearly specific as to when the nominal would be converted into substantial, that only added to the uncertainty. A measure order, he said, you know exactly when that's going to bite, whereas here it doesn't, and that's very unsatisfactory. Now, the actual facts of the case were that there were actually 3 children, the youngest of which was 14. They were shared care. They were in their mid-50s. They'd separated in 2011. The order had been made in 2012. So here we are, some 8 or 9 years on. The wife was a pilot and had been earning $65,000 a year until the pandemic. And this, of course, had prompted her application. And judge felt that the change in circumstances here was nothing to do with the marriage. It was to do with the pandemic. She had been self-sufficient for many years, actually. She had some savings. She had a matrimonial home. She had a share in an inherited property, although that wasn't generating anything. She was not a wealthy lady. Clearly, the refusal of this application meant some potential hardship, but not dire hardship, as her benefits and child maintenance were £2,000 a month. But Nevertheless, this I think is quite a useful little decision. The misfortune, the unexplained events, unexpected developments have nothing to do with the marriage, could not be expected for one spouse to be responsible for the other. Now, as I said, this is a decision by a deputy district judge, but an extremely well-known figure. David Hodson has sat in the Central Family Court Principal Registry for over 20 years and is the founding partner of the International Family Law Group. So one has to attribute some weight to this decision. And as he says on his own website, I believe I am one of the world's leading family lawyers. So there we have it. We are going to see, actually, we're going to see, hopefully, more small or modest money cases reported. Matrimonial and non-matrimonial property. An issue which creeps into an awful lot of our cases these days, of course. Now, in this case, quite a large money case, assets totaling 52 million, another $50 million in an offshore trust, although it was accepted that that was held for the daughters. And the main issues here were, firstly, valuation, and secondly, matrimonialization of inherited assets. As to the first point, the valuation date, this had been specified at an earlier case management hearing, about 2.5, and that date, which was specified, was about 2.5 months before trial. So everything was valued as at that date. I think the date was September 2020 or something. And the husband, of, as you can imagine might happen, wanted to argue that things had changed after that date and to put in further evidence, but the judge refused that. And I have to say, it is potentially a very good idea to pick a date for valuation so that everything is valued at the same date, and that reduces the scope, of course, for arguments about whether things have changed between one date and another and so on. I think that is a good idea in appropriate cases to lay that down, presumably the FDR, so that everybody can focus on that one date. The second point is as to whether the assets have become matrimonialized. And it was said the court will need to analyze carefully whether the evidence will support a finding that property which was originally non-matrimonial has been treated or dealt with in such a way as to bring it within a sharing claim by the other spouse. If the evidence leads the court to conclude that one of the parties had indeed, through words, actions or deed, manifested an acceptance that it should be treated as such, it must then go on to determine the extent. This is a slight, I find this paragraph rather circular. You treat it as an asset to be shared if the parties had accepted that it is an asset that should be shared. Nevertheless, the asset in question here was an investment portfolio which the husband, the wife had inherited, and the husband had managed it for 16 years. There was a lot of debate about whether he'd beaten the market, the extent of his contributions to this, and so on and so forth. But in the end, was unable to persuade the judge that he'd produced a financially measurable uplift in value over and above any allowance for passive growth. Hence, the funds remained non-matrimonial and were ring-fenced. Compare JL and SL number 2. You actually, in order to pick this point out, you have to read JL and SL number 1 as well. But in that case, the wife had inherited assets of 465,000, and she had actually transferred them into the husband's name in order to get better interest rates and to provide for him in case she died. But the court there, Mr. Justice Mostyn, said that did not make them mingled. It did not make them matrimonialized. It did not make them shareable. So that's quite interesting. Even a transfer into the other party's name may not, in the right circumstances and perhaps in front of the right judge, might not be enough to trigger the sharing principle. Matters of procedure. We have the Divorce, Dissolution and Separation Act, which introduces no-fault divorce next April. We have the new FPR 3A.2a participation directions, which applies in all family proceedings. This was amended, I think, in October. And it says here that where it is stated that a party or witness is at risk of being a victim of domestic abuse. Now, the words are where it is stated that. The court must assume the following matters are diminished: the quality of the parties or witnesses' evidence and their participation. So there is a presumption here that the evidence and participation of party or witness is diminished. The words where it is stated that means clearly that the allegation only has to be made. It does not necessarily have to be proved. Abuse includes economic abuse, and hence this provision could quite readily apply in a maintenance pending suit application. So note the use of the word must twice. The court must assume that the quality of the evidence and participation is diminished, and the court must consider whether to make an appropriate participation direction. The next case is M, children applications by email. Now, this decision simply says that whenever a hearing takes place, it doesn't matter what the nature of the hearing is, the same standards of procedural fairness apply. An application made by email or decided on the papers should have the same level of scrutiny. In fact, a judge considering an application on the papers must be alert to ensure that the rules and orders of the court have been followed and that the process is as procedurally fair as if the parties were present in person. So no excuse for not obeying rules or taking shortcuts just because it's not an in-person hearing. In fact, less excuse. Private FDRs are something now, of course, very much encouraged by the judiciary. This particular case, AS and CS, one party should not unilaterally withdraw from, it should say cancel, not conceal. It should not cancel or withdraw a private FDR. The premise is that where the parties have agreed a private FDR, they've done that within the court process as an alternative. And the suggestion is that where you agree a private FDR at the FDA, the order should say that, first of all, the court FDR process is being disapplied. Secondly, it should require the parties to attend a private FDR, and that the date may only be altered by an order of court, although that could be done by consent. I think probably a lot of us have found that during the pandemic, the availability of private FDRs has been a very useful tool, and it is a developing area. There are some talk about the potential of developing a database of private FDR judges. The courts are anxious to legitimise the process, which of course is not at all regulated in any way at all. Unlike arbitration, of course, which is regulated because there are specific rules, and arbitrators have to be a member of the Chartered Institute of Arbitrators. The next decision, next part of procedure, is the latest news from the Financial Remedies Court. It is now fully operational in 18 zones. The allocation system means that you can be allocated to a particular level of judiciary according to the complexity of the case. It is expected that even quite complex cases will be dealt with within the zone rather than having to go to the High Court or Central Family Court. They are suggesting that in complex cases you will get one nominated judge, i.e. you will have your case reserved to one judge. Of course, that judge couldn't do the FDR, but they would carry the case throughout in all other respects. We have already the digital consent order system. The next step is the online digital contested cases system, which they want to put in place by the second quarter of next year. That is something we are definitely going to have to grapple with, and one assumes that that will cover all aspects of the case as we currently see in care proceedings, so that all documents will need to be lodged there, the bundle will be lodged there, the skeleton arguments, any other documents will all be lodged there, and the whole case will be conducted through that portal. The final point is that they are proposing to have a database of judgments for routine cases, as I mentioned the David Hodson case earlier. And I think this could be very welcome, to be able to scroll down and see some modest money cases and how particular judges have tackled them. Whether you could use them as precedents, who knows, but it could be very interesting to see those decisions. The President issued, I think, 3 memoranda yesterday, and the first is about the preparation of orders. He notes that this has become highly adversarial and confrontational process, leading to much unnecessary verbiage and great delay in the production of agreed drafts. The terms of the recitals of an order must reflect the result of the hearing, no more, no less. 3 particular points. Do not include adversarial and partisan statements, or generally any background matters. Secondly, do not attribute views to the court which did not form part of the decision. And thirdly, do not record a party's position before or during the hearing. I think that seems a little bit draconian. I mean, he's talking about finance cases as well as children cases here. I mean, children orders very often do recite positions. I think there's fairly good reason for that. But anyway, he is deprecating this and says all orders should be lodged on the day unless there's a very good reason why not. And if not, then 2 working days later. The next one is about witness statements, talking about the form and content and so on. I don't think there's anything terribly surprising there, but there is inevitably comment that they should not be argumentative, they should not cite law, they should only refer to documents where necessary, they should be limited, it actually says, to 15 pages wherever possible. And there's a template for litigants in person. Now that might be very useful for lawyers when you're against a litigant in person, to be able to give them that as a starting point. There was an old template for litigants in person, which was absolutely terrible, I seem to remember, because it invited them to talk about the whole history of the childhood and the marriage and anything else relevant from ancient history. Anyway, this one is a lot better. Finally, he talks about how we're going to be conducting our court hearings in the future. He says remote hearings are here to stay, very firmly, but it is for individual judges to decide how hearings should be dealt with now onwards. The general direction of travel is that parties and lawyers should attend for important decisions, he says, such as FDRs and final hearings. Interestingly, at the At a Glance seminar a few weeks ago, His Honour Judge Hess felt that FDRs should be in person, but final hearings took place quite satisfactorily remotely, in his opinion. So views do vary. I think where he was coming from is that at an FDR, you need to knock heads together, and it's very hard to do that remotely. The next decision I'd like to look at is a Mostyn decision, E and L. And the husband and the wife were both in their 60s, and they had cohabited from 2016 before they married and separated in 2019. The husband had always supported the wife. He was a successful production manager for live music events, and the wife was a homemaker. In this case, there was the wife sought 5.5 million, which was what she said was 50% of the marital acquest in that short period of time. The husband offered a very limited needs-based award of 600,000. Here there was a lot of debate about the childlessness of the marriage, and the husband, of course, was seeking to invoke the sharp exception to division of assets. And as Justice Mostyn said, he says, I've struggled with the logic underpinning this exception, this childlessness exception. Why should it make any difference, he said, if there's to be an exception to the equal sharing principle for short marriages as to whether the parties had children or not? I put this to Mr. Webster, Simon Webster QC, counsel for the husband, and his response was, the reason it exists is because when one tries to take a step back, you say to yourself, fairness is ultimately what we're arriving at. Is it fair in the circumstance of a short, childless marriage? As Mr. Justice Holman says, having children changes everything. I put to Mr. Webster that whilst this might be true when it comes to the application of the needs principle, it doesn't affect the sharing principle. Why should the presence of a child make a difference to that? Mr. Webster's response was, the having of children denotes a completely different category of commitment. In my judgment, says Mr. Justice Mostyn, this factor should be banished from any consideration of whether there should be a departure from the sharing principle. Whatever may be the true construction of that section of Baronet Hale's speech, it does not include bringing into consideration the childlessness of the marriage, if that were the case. He goes on to say there's no distinction between asset accrual in a short marriage and asset accrual in a long marriage. And he it is a seminal moment because he in fact refers to his earlier decision of GW and RW and concludes that he was wrong. He says, as I explained above, I now figuratively hold my hand in the flames and recant. He says that there shouldn't be a distinction. The shortness of the marriage will be reflected in the outcome by the fact that in a short period of time, the accrual will almost inevitably be less than an accrual over a longer period. He says that in White, it was recognised that there are cases where assets generated by one spouse have been kept separate and should not be shared. A short marriage case. And he accepts that Sharp was applied, and Lord Justice Macfarlane said it would apply in the fringe of cases. Lady Hale talked about great rarity of the exception. Lord Justice Moylan talked about vanishingly remote circumstances. But Mr. Justice Mostyn feels that it is something where it will be as rare as a white leopard, he says. And the reason for that rarity is that it is founded on the notion that the contributions in generating business assets are somehow worth more than those contributed by the other spouse. He says, like the now discredited doctrine of special contributions, this notion gives rise to the Orwellian oxymoron that all contributions are equal, but some are more equal than others. So this decision attempts to confine cases such as Sharp to a very, very small number of situations. In this case, the wife was awarded 1.5 million, which was half the marital acquest. And there was some debate about whether marital acquest should be calculated to the date of separation or the date of the proceedings. And he said, the law needs to be transparent, accessible, comprehensible, simple, straightforward principles. In my experience, convention and tradition dictate that saving cases where there has been undue delay, the end date for the purpose of the calculation should be the date of trial. This rule, he says, this rule of thumb should apply forcefully to assets in place at the point of separation, which have shifted in value between then and trial. For new assets like bonuses earned Post-separation, that's different. That is, anyway, a pretty ringing endorsement of the idea that whilst you can look at pre-marital assets, post-separation assets are much harder to argue. Valuation of companies. Well, here we are in the same case. And when looking at marital acquest, of course, one has to look at the historic value of a company and compare it to the current value. And the question here was whether the valuer can take account of events subsequent to the date of that first value. And Mr. Justice Mostyn finds that not to do so and to rely on figures which are wrong is not consistent with fairness. So what he's saying is that it is an iron principle of valuation theory. So if you look at the forensic accountant's manual, it will say in big black letters, when you are looking at the historic value of a company, you only take account of the information known as at that date. You cannot use subsequent information. And in contrast, he says, in financial remedy cases, actual knowledge of subsequent events is generally used in order to fix a historic value of the asset. This is regarded by valuation purists as little short of heresy. But he feels that to ignore those subsequent facts, and to stick with the facts which were known at the time and which have been proved to be wrong, risks serious injustice. In this particular case, they were looking at the value of the company on an enterprise value basis, and which of course meant finding out what the future maintainable earnings of the company were at that time, or could be predicted to be. And they were using an average of 3 years, a weighted average of 3 years. And in the event, of course, it transpired that that assumption, that average based upon those last 3 years was very wrong. So it produced an estimate of $750,000 a year, whereas as events turned out, it was very much more than that. In the end, what they did, the approach, there were 3 valuers, and Mr. Justice Mostyn accepted the approach of one of them. And that approach was to take a 7-year period, going back quite a long time before and going forward quite a long time afterwards, and take an average of those whole 7 years. And that produced an average maintainable earnings of 2 million as opposed to 750,000. The next point was about when you are looking at an enterprise value and using the conventional formula, of course those earnings of the company reflect not just the efforts of the company, the success of the company, but quite often the efforts and the accomplishments and the skill of the individual within it, in this case, the husband. And it says it's important that one has to look at that, because it is no function of the divorce court, cases like Waggett, to ascribe a value to a husband's earning capacity. It is not a matrimonial asset. And if you're capitalizing the value of a company based on its earnings, then if part of those earnings are the husband, then you're capitalizing his earnings. So what he did, in fact, in this particular case, the accountants agreed that if the husband and his business partner were not prepared to be involved in the sale of the business, as I said, it was a music business, that actually, if they were not prepared to cooperate in the sale and offer themselves in a consultancy role post-sale, this is quite conventional, that actually the business would have no saleable value. So what he did was he applied a discount to the enterprise value for that and various other reasons of 45%. I would suggest that this judgment reinforces the argument that when conducting a company value, where the husband or wife, of course, is an important person in that business, as very often they are in the modest money cases, that there is an argument that you apply a key person discount. I think it used to be called a key man discount, but the wording appears to have changed. Cooper, Hone and Hone was an example going back in 2014, where a business with a goodwill value, this was an investment fund business, which the husband managed. It was said that his relationships and the loyalty to him was an integral part of the business's ability to secure funding and to continue to operate successfully. And in that case, Mr. Justice Coleridge discounted the value by 100% for that reason. So in other words, the business had no identifiable separate goodwill value. There are a number of cases on variation and set aside. CB and EB was, incidentally, a case which I was involved in at the time of the original settlement. In this case, a settlement had been achieved in 2010, and there was a second settlement which imposed a clean break of all claims in 2013. But when the and under which the husband was to pay a further 2 lump sums, but there were 2 properties, very large properties, multi-million properties in St George's Estate, I think, and when they failed to achieve anything like the value expected, the husband applied to set aside the whole deal and to start again. And he relied upon the powers in the set aside under section 31F of the Matrimonial and Family Proceedings Act and the practice direction PD 9A. An application to set aside a financial remedy order can be made when there's no order or error of the court alleged. The grounds may be set aside are a matter for decisions by judges, include fraud, material non-disclosure, mistake, subsequent event, etc. So the husband argued there had been a fundamental change in the legal landscape, and that this is reinforced by the wording of that practice direction, because it says it will remain a matter for decisions by judges. Mr. Justice Mostyn poured scorn on that. The available grounds are the traditional grounds, no more, no less, and so the application failed. Well, that seems fairly clear, and this he slightly disagreed with Mr. Justice Gwyneth Knowles in the Akhmedova case, who was acknowledging that the categories are not closed, but wasn't going much further than that. The next case is a COVID case. In this case, the final order required the husband to pay various amounts, including a lump sum of 49 million in 2 instalments, separated over 18 months. The husband applied to vary the quantum and timing. This is obviously, these is a lump sum in instalments, so there was potential jurisdiction here, on the basis that the COVID-19 pandemic was a barter event and that his assets had been severely affected by the economic consequences thereof. Now, following Westbury and Sampson, Mr. Justice Cohen agreed that it would be very exceptional for the court to vary the quantum of a series of lump sums in circumstances other than a barter situation. He said it was material here that the husband had chosen to pay a capital sum rather than transferring assets in kind, and he said that it was not proper to accede to the application. Here, the husband had not really done himself many favours, because he'd been directed to provide various material, which he hadn't done, and as a consequence, he hadn't really proved that the value of his assets had actually been affected. He was inviting the court really to infer that every business has been affected by the pandemic. And the judge said, well, that's not enough. You've got to prove that your business has been affected. The next case is HW and WW, and this is a decision of His Honour Judge Kloss. The deal was done in this case on the 12th of March, and of course that is very close to the lockdown on, was it the 23rd of March? But that was the day after the husband returned from skiing in Austria. The wife was to get a series of lump sums totaling $1 million within 2 years, with tranches provided for in the order. And he sought a stay, and then he applied to set aside on the basis of the pandemic. Now, His Honour Judge Kloss concluded the COVID-19 pandemic is an extraordinary event, different in scale and nature to any similar world event. It is akin to a war with tentacles spreading across the world. It does not fall within the natural processes of price fluctuation. In principle, it can open the door to a successful barter claim, so the potential is there. However, he concluded that as at the 12th of March, the husband could reasonably have foreseen a risk that the pandemic might impact the trading position of his company. Furthermore, the notice of risk does not require notice of the full extent by which that risk develops. And in any event, an overall assessment of the impact of the pandemic and more general factors leads to an exercise of discretion against the husband. For example, he chose the path of greatest risk by agreeing the deal in its format, namely that he would keep the company and buy the wife out with a series of fixed lump sums. Next, you need to look at the long term, not a snapshot. The fact was the husband's company remained viable and profitable in the long term. It was it was reasonable to assume that. Costs. I hope we're all familiar with the new paragraph 4.4, practice direction 12A, specifically stating that a party that refuses to openly negotiate reasonably and responsibly will be guilty of conduct, and that may found an order for costs, and that this includes in a needs case where an applicant litigates unreasonably. So in E and L, as we saw earlier, there was the husband had to pay 25% of the wife's costs because his unreasonable litigation conduct in arguing that the marital acquest should not be shared at all. Even though, of course, arguably, it is something which is consistent with authority from Miller through Sharp and so on. But there we are. He suffered that penalty, and the wife suffered a smaller penalty for snooping his computer and dealing inappropriately with various correspondence. As Army Morvafach, I'm not going to attempt to pronounce the rest. Here, I'm not going to go through the details of this, but this was about a needs case, and the assets totaled 1.78 million, but the husband had debts of 257,000. And the husband was given a housing fund of 425,000 plus 200,000 towards his debts, leaving him a bit short, of course. On appeal, Mrs. Justice Jant varied the 200,000 and made it on a measure basis. On further appeal, the wife argued she'd have been better off with a costs order because it would have been taxed down. This 200,000 sounds like an indemnity costs order against her. Lady Justice King gave guidance on these cases where a sum is sought just to meet costs when other needs have already been dealt with. She said, you shouldn't be looking at this necessarily as a costs order. You shouldn't be analysing it by reference to the costs order jurisdiction. However, you do need to consider whether it's appropriate to make an order for costs and consider PD 28. And secondly, you have to look at the impact of the extra lump sum and how that skews the award and carry out a cross check. Ultimately, she felt that, and the Court of Appeal decided that the original order was correct. The next case is, again, a debt in a needs case. And here, there had been no findings of litigation conduct against either party. But nevertheless, the wife had been left with cost debts of 180,000 and no provision for them. And on appeal, His Honour Judge Rogers was able to look back at the case and actually effectively make the finding that the first instance judge had not made, namely that she had conducted the case in an excessive and disproportionate manner, pursuing a 5-day trial when she was only ever going to get, frankly, a needs-based award. Nevertheless, her costs were a debt, and this is not to be seen as a backdoor costs order. So he increased the lump sum by 125,000, which went some way towards her meeting her costs, but by no means all of them. Rounding off now, you'll be pleased to hear, ladies and gentlemen, Haley and Haley is a decision about arbitration. I have qualified as an arbitrator. I hope that some of you have had some experience of arbitration. I hope that experience has been good. It'd be very interesting to hear your experiences of arbitration and how you've found that in practice. It is obviously, with the family courts in the state they are, something that we all have to consider in appropriate cases. It's just a question of what we'll regard those appropriate cases to be. The decision in Haley means that, contrary to previous thinking, that the test for the challenge of an arbitral award is the same now as that of an appeal from a court judgment. Was the decision wrong? Not plainly wrong, not seriously wrong, not so wrong it leaps off the page, but just wrong. So that means you can advise your clients that if it goes wrong, they still have the same remedy they would have in the court proceedings. And the case of A&A has given guidance on procedure for challenging an award because, frankly, in Haley and in A&A, the parties have gone round the houses as to the way of doing it, applying to the High Court and under the Arbitration Act and so on and so forth. This is now all being clarified. So it's a simple issue of the Form A, if no Form A has already been issued, a D11 application, a statement in support, a skeleton argument, lodge those, obviously with the arbitral award and any other relevant papers. It will then be put before a specialist circuit judge for permission to appeal, and an inter partes hearing will follow to either uphold or amend the award, or presumably to order some sort of rehearing, whatever's appropriate in the case. Der Harley is a simple case, I think, on enforcement, and I think the takeaway there is that here the wife had been left in possession of a property which was in the husband's name, under an order for sale, but the sale took a lot longer than expected. And the order did not specifically say what rights the wife had to remain living in the property and so on. And it was necessary in this case for it to be litigated. I think the takeaway point is that in those circumstances, make sure your order, your consent order, does deal with the position pending sale, who is to occupy the property, on what terms, what are they to pay for, etc. Crowther is a case about Tomlin orders. A Tomlin order was made in a preliminary issue proceedings within the divorce proceedings, and this is about the interaction between Tomlin orders and financial remedy orders. And note that if you want to enforce one term of a Tomlin order, you might find that you are prevented from doing so if the party you're representing are in breach of another of those terms. In other words, the terms stand or fall together. You cannot necessarily enforce one like you can with a court order, payment of a lump sum. You can enforce that even if you're in breach of one of the other clauses, potentially. And finally, Part 3 MFPA applications, Potanina against Potanin. This, I think, just be aware that this is about the procedure for applications for leave, the filter mechanism, and about the pros and cons and the difficulties which can be incurred there. That it is a quick summary process. So I think time is up. Thank you very much, ladies and gentlemen. We haven't set up any sort of provision for oral questions, but if you do have any queries, please send in email and I will attempt to deal with them. So anyway, I bid you a very good evening. Good night.